Good morning, Judge Wardlaw, Judge Van Dyke, Judge Hillman. May it please the court, Tony Sain on behalf of appellant and defendants below the County of Riverside and Corporal Richard Franzik. If I may, I'd like to reserve 3 minutes of my time for rebuttal.
Yes, please, watch the clock.
Thank you, Your Honor. The court should reverse the amended judgment here for 3 reasons. First, under Seventh Amendment principles, and because courts must presume that jurors follow the jury instructions that were given, it was an abuse of discretion and plain error for the trial court here to amend judgment to find a constitutional violation, whereas here the jury was instructed that in order to find a deprivation of constitutional rights, they must find that the defendant's acts caused plaintiff's ultimate injury, and the jury here found no such causation. Second, unreasonable force by itself without proximate causation of any injury is not actionable or unlawful. And third, on the record that was produced at trial, because it was uncontroverted that there was no fight between Mr. Stoner and any deputy after he was in custody, after the dog bite was over, because the evidence that was uncontroverted was that the only fight between Mr. Stoner and a deputy was during the arrest. His excessive force claim was barred by the Heck Doctrine. Now, to elaborate on my first point, Your Honors, this Supreme Court has held in weeks that jurors must be presumed to have followed the jury instructions that were given. And this precept derives itself from a reliance upon the Seventh Amendment, as the Supreme Court stated in Gallic. Under the Seventh Amendment, only juries can decide disputed facts. Here, the jury was instructed at jury instruction number 27, record page 350, that in order to find that the defendant deprived Mr. Stoner of his particular constitutional rights or his legal rights, including a California law battery, the jury had to find that the defendant's acts were the moving force that caused plaintiff's ultimate injury. And here, in response to the question of whether or not defendant's conduct caused Mr. Stoner's harm, the jury answered that question with a firm no.
So counsel, on the verdict form,
yes, Your Honor.
The judge set out, if you answered yes to question 2, go to question 3. If you answered no to 2, stop here, no further questions.
Yes, Your Honor.
Doesn't that imply that that's the end of it?
Yes, the end of the inquiry was, yes, Your Honor. The end of the inquiry was the jury's finding of no causation of any injury, and therefore the jury stopped answering questions because, according to jury instruction 25, if plaintiff had failed to prove any element of their claim, the jury was obligated to enter a defense verdict. By ending their inquiry with the failure to prove causation, the jury rendered a defense verdict, as was entered in the original judgment.
Counsel, can you give me an example of something that would be excessive force but wouldn't be proximate, like it wouldn't meet the proximate cause standard? So, I mean, I'm trying to figure out like I mean, it can be from this case, but I mean, even just generally, like what would be excessive force but wouldn't proximately cause any injury? Because I think that's the key. It has to not proximately cause any injury. Some of these cases say it caused some injury, but not compensable injury, right? And that's when you get the nominal damage. But I'm talking about excessive force that doesn't cause any injury.
Yes, Your Honor. Actually, this court has already addressed that issue in the Mendez case when it adopted or referenced the hypothetical raised by the Third Circuit in Bodine. And what the Bodine court hypothesized is that you could have officers engaged in an unlawful search or an unlawful seizure, but in the middle of that theoretically unlawful conduct, a search without probable cause, a seizure without justification, in the middle of that theoretically unlawful conduct, the suspect could grab a gun, point it directly at the officer, and as a result of that intervening action, any officer harm that resulted, where the officers then shoot the suspect, the officers would not be liable for the harm that resulted to the suspect because of the suspect's superseding cause of his own harm. And the court here embraced that in the Mendez case. Now, it's possible that the jury here, in analyzing the facts, determined that Mr. Stoner was the superseding cause of his own harm. They may have determined that because he fled from police for over 45 minutes, tried to run over a deputy who was on foot, ignored commands to stop, ignored the canine warning, got into a fist fight with the deputy in the field, and then tried to rip the dog's bite off of his legs. The jury here may have concluded that if Mr. Stoner had suffered any injury at all, He was the superseding cause of that injury, which, as this court has found in both White and Mendez and Arnold and Harper, when you break the causal chain, there is no liability that otherwise would result to the defendant.
Sure. I think we're probably following you on that, but what would the jury, in that circumstance you're talking about, what would the jury have thought merited a yes answer to the first question? That there was, the jury must have reached the conclusion there was something that was excessive. What would they have thought was excessive, but did not actually cause him any injury?
The jury, in following jury instruction number 26, which talks about what is reasonable force under federal law, which was undisputed in this case that the standard for excessive force or unreasonable force under federal and state law was the same. But the jury here was only analyzing the reasonableness of force, not whether or not the reasonableness of force was unconstitutional or unlawful. In fact, on close review of jury instruction 26, the word unlawful or deprivation or violation doesn't appear in there anywhere. Where the concept of unlawful excessive force that is unreasonable, that is unconstitutional, where that concept is first introduced is in jury instruction 27, the very next instruction. And it holds that in order to find a violation of the Constitution, the plaintiff had to prove that the defendant's act was the moving force that caused plaintiff's ultimate injury. By finding no such causation, the jury, following that instruction, can only be construed to have found that there was no violation of Mr. Stoner's constitutional or legal rights here. Now, it may be that they found it that way because they determined that Mr. Stoner's conduct was a superseding cause of harm. It may be that they found that the excessive force, the unreasonable force, occurred after the injury at issue. We don't know. All that we know is that they found a break in the causal chain sufficient enough to determine that there was no constitutional violation here. And therefore, because the trial court amended judgment to disregard that found fact, it was violating the defendant's and appellant's Seventh Amendment rights.
I just would like to understand your argument a little more precisely. You're saying that the constitutional violation subsumes the causal connection. Is that what you're saying? That it couldn't be, if you're looking at jury instruction number 26, it says under the Fourth Amendment, a peace officer may use only such force as is objectively reasonable. And so when the jury's answer to question one, they said the force was unreasonable for a constitutional violation. But number two, that force that occurred, or that unconstitutional violation, did not cause Mr. Stoner's injury.
No, Your Honor, that's not what
And
I'm saying.
you're saying you cannot divide up the constitutional violation in that manner?
That's not what I'm saying either, Your Honor. What I'm saying is that jury question one does not address whether a violation of law occurred at all. Contrary to what the trial court held, there's nothing in that question that mentions the word constitutional violation, unlawful, or anything like that. Nor is the concept of a violation.
Well, it says excessive force, which is the concept is in instruction number 26 as a Fourth Amendment violation.
No, Your Honor. Jury instruction 26 does not actually say violation. It doesn't say deprivation of right at all. A jury reading 26.
It's about the Fourth Amendment, right?
Yes, Your Honor, it does, but it doesn't say that unreasonable conduct violates the Fourth Amendment. The concept of violation of constitutional right is not introduced in jury instruction 26. It's introduced in jury instruction 27. And this court, in multiple cases, has held.
Question number one asks excessive or unreasonable force, and that's the language that's discussed under the Fourth Amendment in jury instruction number 26.
Correct. And neither jury instruction 26 nor question one on the verdict form use the words unlawful, unconstitutional, violation, or deprivation. The concept of a violation of right is not introduced until question two, jury instruction 27. And this court has repeatedly held in Mendez, in Arnold, in Harper, and the Supreme Court has held in Martinez that absent proof, proximate causation of an injury, any injury, there cannot be a constitutional violation under Section 1983. In fact, this court's model instruction, number 9.8, specifically holds that you must prove causation of some injury, any injury, to establish a constitutional violation. And here, the jury found no such causation, which means following jury instruction 27, they found no violation of Mr. Stoner's constitutional or legal rights. Additionally, it's important to note that the amended judgment does something that's a little bit novel in that it creates an inconsistent verdict. Whereas the original verdict and the original judgment was consistent, the amended judgment transforms the judgment for defendants on the 1983 claim into a judgment for plaintiffs, but leaves the judgment for defendants on the battery claim, even though it was undisputed on the record that those two claims are decided by the same legal standard. It's also worth noting that the finding of fact that the jury reached under the Gallic and under the Seventh Amendment, this trial court committed plain error by ignoring that finding of fact. A court is not permitted to disregard a jury's factual findings, and it's a violation of the Seventh Amendment to do that. This court held in the Rabkin case, which is at site 350 F3rd 967, that an abuse of discretion or plain error constitutes a judgment that ignores the facts as found. Well, the only construction of this verdict form, assuming a jury follows the instructions given, is that this jury found no constitutional violation. And folks, so for this court to go back and amend judgment to find a constitutional jury violation where the jury found none is a clear violation of the Seventh Amendment and a clear deviation from the Supreme Court's mandate in Weeks. Now, turning additionally, another basis of relief that the appellants have argued is that Mr. Stoner's claim was barred by the Heck Doctrine. Mr. Stoner pled guilty to violent resistance to a peace officer who was lawfully engaged in the performance of his duty under California Penal Code 69. The factual basis of that plea was that Mr. Stoner was fighting with a deputy in that field. Now, the
resisting arrest by Deputy Thur, right?
Yeah, yes, Your Honor, among others.
Not that he was doing anything with respect to Deputy Stoner.
That is true. But I'm sorry, I think you meant Deputy Franzik, Your Honor.
Oh,
that
right,
is true.
Right. Yes,
That's okay, Your Honor. That is true, Your Honor. However, the issue is whether or not Mr. Stoner's, the factual basis of his excessive force claim materially contradicts, undermines, or impugns the factual basis for his conviction. Now, the factual basis for Mr. Stoner's excessive force claim is that when he's out there in that field, he's not resisting anybody. He's not a threat to anybody. That's his factual assertion. However, the judge, in denying defendant's motion for summary judgment, theorized that maybe when he pled guilty to the PC 69, he was talking about a post-bite fight, a post-cuffing fight. Well, the undisputed evidence at trial showed that there was no such post-bite fight. There was no post-cuffing fight with any deputy, which means the only fight that could have formed the factual basis of his conviction was the mid-bite fight, the fight during the arrest. And so for Mr. Stoner...
It could also be that he was fleeing. He was fleeing Huer and resisting Huer even before the dog got to him.
That's not the factual basis that he stated in his allocution, as is indicated at record pages 652 through 659. The factual basis of his plea is that he got into a fight with Huer, and the evidence presented at trial showed that the only time he got into a fight with Huer was mid-bite. And because of that, because the factual basis of his excessive force claim directly contradicts and materially and fatally contradicts the factual basis of his guilty plea, his excessive force claim should have been barred by the Heck Doctrine. And in light of these facts, Your Honors, in light of the fact that the court ignored the jury's factual finding of no constitutional violation, in violation of the mandate of the Supreme Court in Weeks, in violation of the Seventh Amendment, and in light of the fact that plaintiff's claim was Heck barred based on the evidence produced at trial, the defendants and appellants here are respectfully requesting that this court reverse the amended judgment and reinstate the original judgment in favor of the defense. Thank you.
Thank you, counsel.